So I actually, it's a critical appraisal from my side as a competition activist, I would say. So in my first article, I basically dealt with the gaps in enforcement have not been completely removed. Section 4. You will be surprised, Sumit, to see there's not even a single mention of Section 4 on the entire Act. Competition Amendment Act doesn't talk about Section 4 at all, as if abuse of dominance was absolutely okay. There were gaps. There were gaps. Anti-competitive agreement is fine. Section 3 and Section 4 you have dealt with. But what about Section 4? So in my first article, I mentioned the case of e-commerce companies. So there is Uber, there is Ola, there is Amazon, there is Flipkart, right? All of them are big companies. All of them are doing wrong things. They are doing deep discounting, for example, or they are doing preferential selling. They are doing surge in rankings. What will happen to them? Because they will never be dominant, but they are doing conduct which is anti-competitive. So what the law as such today states is there's a form-based approach. Under Section 4, there are 5 limbs of Section 4, which says you will not do this, 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 this. If you are dominant, it will be deemed to be abuse of dominance, right? So it's a per se approach against an effect-based approach. We as experts have spoken at length, have written articles and done so much to the Competition Law Review Committee, even to the Parliament, the Standing Committee. Please do something on this. It's a farm-based approach should be done away with. Even in the Google case, let me tell you recently, and it is in my blog, the NCLAT, while dismissing the appeal of Google, recently, it's a very recent judgment, of 29th March. Let me just see. Yeah, 30th of March. This order of NCLAT 30th March says that they agreed with Google that effect-based approach should be applied. That means you must show that your conduct has resulted into effect on competition. This was the defense of Google. That whatever I'm doing, where is the effect on competition? But say no, because Google admitted you are dominant, and that they cannot deny. Google is Google. Just because they were dominant, they were penalized. So this is the first biggest issue which, and that's why I suggested in my article, like US got a provision to attempt to monopolize. So if Amazon or these big giants, they do something which is Uber, for example, if it is finished in the taxi market, if it is actually doing so, why should it not be inquired? Why should it not be investigated under Section 4? It's attempt to monopolize the market. You understand? When you're doing a conduct which is apparently anti-competitive, you cannot, under the present law, be penalized, or you cannot even be investigated by the CCI because there is no law to that effect. So called form-based approach against effect-based approach. That is the first bullet which I said in the first article. And the second article, when the second bill came, I found that also was missing. In the 22 bill also, the form-based approach was not touched. Section 4 was left as it is, as if there's everything hanging down. And the another point where I'd like to mention is there is no, mention about IPR. For example, intellectual property rights and abuse of dominance. So if you are a patent holder, right, and you misuse that patent for some reason or the other, you cannot be, you can be prosecuted under Section 4, abuse of dominance. Under Section 3, you cannot be, because there is a exception carved out for Section 3(5) for all IPRs. And it cannot be anti-competitive agreement between a patent holder and its licenses because they have a benefit of Section 3(5). But what about Section 4? I'll give you the very excellent example of, if you may have heard of Bayer case. Bayer was compulsory licensing. Bayer was selling a drug which was 2.8 lakh, maybe my figures are not correct, 1.8 lakh dose for cancer drug. Dexavar produced the same drug at 8,800 rupees after it got the compulsory license on public interest by the patent board. Matter went to Supreme Court. Supreme Court dismissed the claim of Bayer. Yes, it is in public interest. You can be asked to give license to your patent, compulsory licensing. That was under the Section 85 of the Patent Act. You know what happened? United States of America, after that decision, put India under Super 301 watch list. Even today, we are under Super 301 watch list. All our IPR regimes are looked with suspicion by these big countries because we use the compulsory licensing from the IPR laws. But what if Section 4 is invoked by CCI today? They can do it. Well, unlike Section 85 of the Patent Act, where there's a cooling period, 3 years. There's no cooling period in the Section 4. So if you're an IPR holder, you can easily I can drag you to the CCI. I can say, look, what you're doing is unfair pricing. Well, Section 4A talks of unfair pricing. So if a price is unfair, too or excessive, then you can be certainly summed up. Can it happen? It can happen. It's a gray area. So similarly, I also, in the second article, I talked about I was critical of material influence, a test of control, which could lead to gun jumping, and even structural issues, because I was a part of CCI at the time when CCI was being made. CCI enforcement had not started. We were there for 2.5 years. Mr. Vinod Dhal was our member of CCI, sole member. So we said CCI should not become MRTV Part 2. Why? Because there was no functional autonomy. CCI should be functionally autonomous. So for that, you need financial autonomy. So I gave the specific suggestion to the standing committee that please do something about financial autonomy of the commission. They have no source of revenue like the SEBI, separate except for the fees which they derive from the regulation filing, which of course is quite high now. And the second point was lack of judicial member. The Mahindra judgment of Delhi High Court has said that CCI without a judge, the judicial member, is not a proper quorum. You cannot adjudicate on highly technical legal issues which affect industry at large, and it affects economy without the judge being there, right? They actually scrapped that judgment, but there's no clarity. And then last but not the least, no clarity on DG. Just explain legal, whether legal advisor will include external counsels or not. This point I also touched in the second article. And as an activist, Sumit, I must confess that I have written wherever I get a chance. I've even approached the finance minister wherever, if I could get the time. I approached Mr. Jen Sinha personally. I gave him the suggestions in writing. They were considered, they actually accepted, but unfortunately in the bill or in the act, they have not been. This suggestion has not been accepted. The last one.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.